Good morning. The next matter before the court is Robert Rising versus Litchfield Board of Township Trustees. Do you wish to reserve any time?
Yes, Your Honor. I'd like to reserve 3 minutes for
3
rebuttal.
minutes.
Good morning. May it please the court. I'm Ted Lesiak, representing Robert Rising. We have one assignment of error, and today that is that the judgment was against the manifest way of the evidence. This case arises out of a prescriptive easement action, a quiet title action, to obtain a prescriptive easement. Mr. Rising's parents purchased his property in 1945. Mr. Rising was born in 1951. In 1977, Mr. Rising's mother passed away, and Mr. Rising's father took title to their property, took sole title to their property. In 1980, Mr. Rising's father passed away, and Mr. Rising, my client, took title to the property himself. In December of 1999, Litchfield Township purchased the property directly north of the Rising property and immediately adjacent to it. Prior to 1999, the Risings had an opening in the north end of their property whereby they drove vehicles through that opening and onto the property purchased by Litchfield Township in 1999, basically as a turnaround. The driveway on the Rising property is on Avon Lake Road, Route 83. And the driveway would come into the property, and you could come through the opening and go out onto the property purchased by Litchfield Township and go out to the traffic circle in Litchfield, which is Route 83 and Route 18. So they kind of used it as a turnaround rather than having to back out onto Route 83. What happened was in 2010, Litchfield Township decided to barricade the opening that would prohibit vehicles from entering into what was now their property from the Rising property. As a result, Mr. Rising filed a quiet title action seeking a prescriptive easement and also, obviously, seeking to enjoin Litchfield Township from continuing to barricade through the opening of the driveway. This case has been here on appeal once previously on a motion for summary judgment. The motion for summary judgment was granted in favor of Litchfield. That was reversed, sent back to the trial court for trial, and trial was held to the court. Now, basically, the party claiming a prescriptive easement must show that the easement was open, notorious, adverse to the neighbor's property rights, continuous, and at least 21 years in duration. One of the issues we have here is that Mr. Rising was the owner of the property for 19 years before the barricade was placed by Litchfield Township. So we're also looking at a tacking issue. In other words, Mr. Rising is looking at obtaining the 21 years of use on the easement through the use of his parents as owners of the property prior to Mr. Rising. With regard to a prescriptive easement, Mr. Rising does not have to show that he had exclusive possession of the property for all 21 years. That tacking can't apply. What he has to do is show that there is privity between Mr. Rising and the previous owners, which obviously he had that as he obtained this property from his parents through their estate. And in fact, the trial court found that there was privity in this action. The issue before you is, as I said, it's a matter of whether the evidence presented at trial, the judgment of the trial courts was against the manifest weight of the evidence. with regard to the use of this easement. Specifically, the trial court hung its hat, if you will, on the fact that Mr. Rising was not actually living on the property in two periods of time. In 1970 to 71, Mr. Rising was a student at Ohio University and was not actually living there because he was in college. Between 1974 and 1979, Mr. Rising was living in Grafton, Ohio, and Mr. Rising came back to live on the property after 1979. Now, the evidence presented at trial was unrebutted by Litchfield Township. What Mr. Rising testified to at trial was that during the time that he was in college, that he came home from college approximately once a month, and during this time period, he used that particular easement himself with vehicles, and that he witnessed his parents using that easement. Now, Mr. Rising also testified that during the time that he lived in Grafton between 1974 and 1975, that he used the easement approximately once a week when he visited his parents, and sometimes up to 2 or 3 times a week. And once again, he also witnessed his parents using the easement. So basically, from the time that Mr. Rising could actually drive a vehicle, he had been using this easement. Now, what the trial court said is that the use of Mr. Rising that he testified to, that basically that he used it once a month in 70 to 71 and up to 2 to 3 times a week in 74 to 79, was not continuous use. But basically, the difference between continued or sporadic use, or as Mr. Rising said, not every day, the difference between that and abandonment of the easement is the issue. The easement was never abandoned. According to Mr. Rising's testimony, the use was always continuous. Specifically, the case law has been set forth in the 4th District that continuous use can be use up to 1 year. Once a year would be considered continuous use of the easement. The case is Dunn versus Ransom, and the case states that the acts of a prescriptive claimant do not need to be daily or constant. Rather, occasional use will fairly indicate uninterrupted use to the true owner, and that will suffice to put the true owner on notice that there is continuous use of the easement. In this particular case, the issue is whether the easement was abandoned, and there's unrebutted, clear testimony from the case, from the trial, that this use was continuous throughout these periods of time when Mr. Rising was not living on the property. As the easement wasn't abandoned and was continuous use, and that the evidence presented to the trial court was unrebutted, clear and convincing, this court must reverse this case based upon the fact that the evidence is, the judgment is against the manifest weight of the evidence. Thank you very much.
And you have a little over 6 minutes remaining, and you reserve 3. You can use your full 5 if you wish.
Okay. I'm fine right now, Your Honor.
Okay.
Thank you.
Good morning, Your Honors. Excuse me. Good morning, Your Honors. My name is Tom Karras. I am an assistant county prosecutor in Medina County. I represent the appellee in this matter, the Board of Trustees of Litchfield Township. In any matter where the sole error that is being cited by the appellant is that it's against the manifest weight of the evidence, this court, in determining whether the judgment is indeed against the manifest weight of the evidence must give every reasonable presumption in favor of the judgment and the finding of facts. The rationale for this is that the trial court has the sole opportunity to observe the demeanor, the gestures, the voice inflections, and to observe the testimony of the witnesses. In this case, the appellant's only witness was Mr. Rising himself, and he testified that in looking specifically at years 1978 and 79, that he was not living on the property, but he recalled that his father used the area which they're seeking a prescriptive easement. That's true. There was no rebut of that testimony, but also there was no corroboration of that testimony, and it is very, very possible, if not likely, that the trial court saw this testimony as merely being self-serving and would go to the credibility of the witness. The burden of proof in a matter such as this, and that was stated by this court in Hutchkins versus Stratos in 2005. The burden of proof on the plaintiff is by clear and convincing evidence. Simply this testimony that he remembers his father using the property in a similar manner as he is using it is not meeting that burden.
Counsel, are we looking at whether the trial court believed or disbelieved the testimony of Mr. Rising? Or are we looking at whether the trial court applied the appropriate legal standard? That is, the trial court seemed to suggest that if he lived away at school, in other words, he was a resident somewhere else, that he could not, meet the requirements of this continuous possession. And so if the trial court was incorrect on that legal basis, do we really look at credibility of the witness?
I don't think that the court was looking at the fact that he was away as to go to his credibility, because as appellant's counsel has pointed out, this issue involves tacking as well as the 19 years. He lived on the property and used the property in such a way. He used the so-called prescriptive easement a certain way for 19 years, and the requirement is 21 years. So what they're attempting to do is show that his father also used it in a similar manner those 2 years prior. So 79 and 78. The fact that he was away at college early in the 70s is not really relevant. It was more what happened in that period of 78 and 79. And part of the requirements in order to prevail with tacking is a showing that the property was used in the same or similar manner. Now, Mr. Rising testified at trial that he used that driveway for his commercial business. He runs a firewood firewood, he sells it, he processes it and sells it. And he also receives deliveries on his property, and they use, not only did they use the driveway coming off of Route 83, but they also used the township's driveway to bring in trucks. For instance, he mentioned a lumber truck that would from a utility that was carrying a large stump that would go onto the property, because it was more easy to access the back of his property from this easement. So, but he also testified that his father did not engage in any commercial activity on the property. So I think they fail in that 78, 79 period. The appellant fails because of the element of same or similar manner.
But the father did use the property through that property for access. You're saying it wasn't a commercial purpose, and that
it wasn't a commercial purpose. His father didn't have, excuse me.
I'm sorry. Does it have to be the precise same use, i.e. commercial, or can it just be needing to use the property to get from A to B for whatever purpose?
I think you have to go deeper than just traversing across the property, because obviously the demands on that property itself, if you have commercial trucks, you have large trucks coming over and carrying lumber or carrying timber that needs to be processed, is not the same as just cutting across the driveway. Now the reasons that the defendants here, the Litchfield Township, put up the barriers was because of this commercial activity. They have a community center right in the area exactly where the cars are coming out. The entrance to the community center. That community center is used for a lot of things, including Boy Scouts, Girl Scouts, and other community activity. And if a large truck literally comes from out of sight and comes right past that door, they saw that as a risk and a danger to the community. The other irony about this is that we're not talking about the whole driveway of the township. We're talking about a strip of land which is approximately 15 feet wide by 30 feet long, because that's the distance of this property, this particular property that was purchased. It was backland that was purchased to extend the township's parking lot. The other properties in front of that, which he was traversing over, was purchased. Some of it was purchased in the 50s. Some of it, the original townhouse, was actually purchased in the 1800s. So they could never get a prescriptive easement over that area. The only prescriptive easement they could possibly get would be approximately, like I said, 15 feet wide and 30 feet long. So that does not give them the right, even if you were to award them the prescriptive easement, that would not give them the right to go over the driveway to get to Route 18. So if they were using this property merely as a turnaround, because that's the only conceivable thing that I could think of for 15 to 30 years, if they were using it as just a turnaround, then maybe that is a prescriptive easement, but there's no evidence of that. There's no evidence, and there's no evidence that other than, like I said, self-serving testimony by the plaintiff, that the father used it in a similar manner. And I think it is important to point out that his purpose for using that property is primarily commercial, as opposed to just taking a shortcut instead of going out to Route 83, getting right out to Route 18. Therefore, I feel that the trial court was correct in denying this prescriptive easement, because simply the plaintiff did not meet the burden of clear and convincing evidence, and that is why the trial court denied the claim of the plaintiff.
Thank you. You still have 3 minutes if you wish to use them.
Okay.
So you have 5 minutes if you wish to use them.
Thank you, Your Honor. I think if you look at the order from the trial court was looking at an issue of abandonment of the easement. In other words, that Mr. Rising could not say that he used the easement in a continuous manner in the times that he was, quote unquote, from the order absent from the property. Therefore, he could not say that there was a continuous use, because he was not living on the property, he did not own the property at that time. And I think that is the issue where the court went into error at that point, because there is clear and convincing evidence that Mr. Rising was aware of his parents' use of that easement during those periods of time that he was, quote unquote, absent from the property. And in fact, he himself did use that easement during those periods of time.
And how would you characterize the use by the parents? The frequency and the type of work or whatever was going on with the parents' use of that?
Well, the record will show that even if that Mr. Rising himself uses this easement for various things, including his own convenience with his own vehicles. It is true that Mr. Karras is correct in saying that at times there were, what Mr. Rising's business was a wood selling business.
And was his father or did his parents make use of it for a similar purpose or just for personal convenience?
Basically, not for that particular commercial use. However, they did use it. But Mr. Rising, you'll see from the record, testified that he used it for his own convenience, for his own cars, and it wasn't just a commercial purpose. So that the use is a similar use in order to apply the tacking standard. However, like I said, Mr. Karras is correct. Mr. Rising said, well, I've used it for various reasons, including having log trucks come in and it's easier for them to go out that way. The issues as to the extent of the easement, I mean, that's an issue with regard to what the township were to determine to do if the prescriptive easement were granted. We are only talking about a piece of property in between the town hall property, which Mr. Karras is correct as to the size of that. However, a turnaround, it would only be a turnaround should the township decide to block it off on their property further in. And now the township property, the township hall's been there since the 1800s. But also there's testimony in this case that even one of the trustees has used this easement for his purposes. So others have used this easement as well as the Risings. And like I said, the issue is whether this easement use, in other words, vehicles traversing over the easement, has been abandoned. And based upon the unrebutted testimony in trial, this easement has been in use as far as Mr. Rising can remember. And as I said, he was born in 1951. He testified that he started using this easement himself with vehicles when he learned how to drive in the 60s. He used this easement throughout the 70s, even during the time he was absent from the property. and he used this easement after Litchfield Township purchased this property in 1999. And it's been up until the time that it was barricaded in 2010. So there has been a continuous use, and that was the issue with the trial court, that because he was absent, the use was abandoned during those times for tacking purposes, and that is just not the case. As a result, we're asking that you reverse this case as being against the manifest weight of the evidence. Thank you very much.
Thank you. We will take this case under advisement and send you a copy of the written opinion when it is issued, and you can also find it on our webpage on the internet. Thank you, and have a good day.